judicial analyst. He joins us with his thoughts. Good morning, Jim.
Good morning, Sean. The Comey case just keeps getting curiouser and curiouser. So Daniel Richman is a professor at Columbia Law School, a former colleague of Jim Comey's in the Justice Department. I might add, a very well-respected lawyer and legal scholar who advised Jim Comey numerous times during his tenure as director of the FBI and afterwards. In an unrelated matter in which Mr. Richman, Professor Richman, was not the target, the FBI seized his computer and the contents of it and accessed attorney-client communications between Jim Comey and his lawyer, Professor Richman. And it used that information in the first indictment of him. Now that indictment has been thrown out. They still have that information. They want to use it in an effort to get a second indictment, and a federal judge said, no, you can't use it. We don't even know if they can get an indictment without that information that they seized from Professor Richman, number one. Number two, we also know that it's too late to indict him again because the statute of limitations that's expired. This just adds another obstacle to the government's efforts to indict and prosecute Jim Comey.
All right, so it's possible but not likely. Is that where you would lean in terms of a second indictment on the former FBI director?
It's extremely unlikely, and this setback will give them pause.
All right, let me move on to this D06 control. This one is the Supreme Court hearing this case, Trump v. Slaughter. This is a case that challenges the president, his firing of Rebecca Kelly Slaughter from her position at the FTC, the Federal Trade Commission. You may be seeing this in the news. Lawyers are arguing that this case could impact the Supreme Court's 1935 decision on removal protections. Talk to us about this.
Yeah, so in 1935, President Roosevelt decided to remove a bureaucrat who was appointed to one of these commissions, last name Humphrey. Yeah. Humphrey died. The executor of his estate sued the government for the money that Humphrey would have made had he lived and not been fired. And the Supreme Court said FDR was wrong to fire him. This is effectively a separate branch of the government. What do you mean separate branch of the government? We have three branches of the government. The view at the time of administrative agencies were that they were not in the executive, not in the legislative, not in the judicial, but some sort of fourth branch on their own. And once somebody was in that branch, they couldn't be removed. Fast forward 70 years later, a young lawyer in the White House named John Roberts is writing a memo to his boss, Ronald Reagan, saying this opinion is wrongfully decided and someday the court will undo it. 10 years later, another young lawyer, this one in the Justice Department, named Sam Alito, is writing a memo saying this opinion was wrongfully decided. There is no fourth branch of government. We know where they are now. There are two members of the Supreme Court. The case is going to be argued today. Look for this 1935 precedent, which gives basis to the view that we have a fourth branch of government, finally, after 80 years, to go away. Yeah. 90 years, excuse me.
The way you laid that out in terms of history of these two men now sitting on the Supreme Court, to be able to now finally have their moment and how they saw this, very interesting.
Information. Truth is freedom. Is Newsmax. It's real news for real people.